somewhere.
I already
Thank
started.
you.
Thank you.
Perfect. And yeah, I will give you the floor, Alex. Welcome everyone to this session today. Um, and yeah, let's just start with the presentation today. Thank you, Alex, and everyone for joining.
Perfect. Thank you so much, Jimena, and thank you everyone else for attending. Samuel, Jose, obviously, thank you very much too for all of your coordination work. And I appreciate all of you joining us again twice in 1 week is a lot. And I do love to see the messages in the chat saying hello from everyone. It just, I think, is a nice welcoming environment for us all. So we will continue today where we left off on Tuesday, and that was talking about international environmental law. So I will share my screen and see how many times it takes me to put it in proper presenter mode, but we shall see. So always do bear with me, please. Let's see.
Take your time, Alex.
There are all you lovely people. And let's see, why is it doing a delay? Let's see. That's very odd. There we go. Okay. That should be working. And then let me do this as a, let's see, you don't want to see this. You don't need to see this. Are we doing a screen share?
Yes, you're sharing your screen. We're just missing the presentation mode. Now
The actual
we're not.
presentation. That's why, because I'm still learning how to use two screens. Years after the pandemic, I'm still learning how to use two screens properly. It's quite entertaining. So let me try this again.
I was
And
finding the recording button before today and couldn't find it, so don't worry.
it's amazing how that works, right? It's, technology is amazing until you have to use it. Anyway, let me put this into presenter mode. So hopefully that works better. There we are. Okay. Is that working?
You just need to change it to the other presentation mode,
Okay, excellent.
like last time. Yes.
That one?
Perfect. Yes.
Excellent.
Go
Okay,
on.
good.
It's good.
Excellent. Thank you. Thank you both. All right. So, as we hopefully remember at least a wee bit, on Tuesday we talked about international environmental law. And we started out with the idea of the history itself of international environmental law, as well as its development, and noted that unlike a lot of other areas of international law where we have things that are really well established practices, so diplomatic practice and the rights of embassies to be and ambassadors and their staff, et cetera, and their family to be free from interference, et cetera. We have, which is a very
Sorry, Miss Alex, you're muted. Yep. You may unmute yourself again. Yep.
yeah,
Thank
there
you.
we go. I don't know how that happened. That's very strange. But thank you. Tell me if anything else happens. It's that kind of day, I think, with technology. That was supposed to be on the 1st of April, but I feel like the 3rd is instead that kind of day. So we talked about the history of international environmental law. We talked about how things are very new in the environmental law field compared to things like advanced ideas of diplomacy and diplomatic protections and also trade protections, which happen or have happened for basically time immemorial, but international environmental law is quite new. So we talked about that. We also talked about the concept of a multilateral environmental agreement, or MEA, or usually they're referred to as MEAs because it's more than one. And we talked about the existing MEAs. Now we talked about many of them. There are obviously many more that are extremely niche, but there are many of them that we discussed. So we talked about everything from the UN Framework Convention on Climate Change and CBD, Convention on Biological Diversity, and also the Desertification and Drought conventions, which came to us from 1992 onwards. We also talked about the CITES Treaty and the Ramsar Convention. and looked at things like the Basel, Rotterdam, and Stockholm conventions, so pollution, also the Minamata Convention on pollution, on mercury. So all of these things which have a very strong connection, obviously, to environmental concerns as well. So we talked about a lot in a relatively short period of time, which always surprises me when I do these sessions, how much we can get into quickly. So today we're going to be talking about the idea of nexuses. So the idea of having a nexus, a connection point between different types of MEAs themselves, and then also MEAs and other forms of international law, so other treaties. And we'll also touch on some regional laws as well. So hopefully this will be a good way for us to think about how we have developed international environmental law and how we are developing it. And then also how we make sure that those developments don't overlap too much, or when they overlap in a way that works together and doesn't cause a conflict, but instead causes what we call convergence and causes two or more regimes that work together well to advance a particular point or particular interest. I will give a bit of a kind of a heads up or a foreshadowing that this is an issue that comes back to us again when we talk about particularly the plastics treaty. So when we get into week 4, really, and we start talking about the plastics treaty, the negotiations, and using that as a case study for everything we've learned in the first 3 weeks, you will see that the issue of regime convergence, which we'll talk about momentarily, and this idea of the intersections and the nexuses between the proposed plastic treaty and then other types of international law, especially MEAs, is a really important one. So, and very controversial. So it's one of those things to keep your ears open for here as well. But before we get there, I know that we had a number of questions in the chat on Tuesday. And I don't want anyone to think that we forget your questions or that we hold on to them for the weekend only, because they are really quite important and they're quite interesting. And I want to clarify some things that came up in those questions, and then also that came up in the WhatsApp chat for those of you who have opted to join the WhatsApp group chat and ask questions. Please pardon the need for coffee. I've been up since a very early hour. So the first question that came up was one that was from someone who's involved in negotiating soft law and working with some soft law guidelines. And the question was, why do we need, or do we actually need, binding international treaty texts if we also have soft law in the same field, or soft law instruments in the same field? And I think this is a really good question. It's a really fundamentally important question. And there are several reasons we need this. First of all, as we've seen, soft law is of limited actual enforceability. So soft law has a great deal of power, potentially. It has a great deal of presence in international law. It is the second highest source that the International Court of Justice thinks about when it thinks about sources of international law. But at the same time, it is not considered to be legally binding. And so it is not considered to be the highest level of international law source, which is a treaty system. Thus, it is entirely voluntary, unless a state believes it is acting in a customary practice, but even then it's easier for a state to break that practice. Having soft law become binding law over time, or creating international treaty texts over time that are based on soft law, is a way to make sure that those types of treaty issues and concepts are actually put into practice in a more enforceable way. They're more enforceable in the international community in terms of complaint systems and compliance reviews, and also oversight and monitoring. And they can also, as we've been seeing more recently, especially in the UNFCCC context, be used for as the basis for things like national as well as international litigation and court cases if they are not actually complied with. So it is important to have that. And it's also important to set standards and create things in many instances like trading regimes, licenses, import-export requirements, etc., that you wouldn't really have because you wouldn't have a legal basis or a commonality of understanding between soft law adhering governments, but you do for the binding treaty state parties and ratification processes. So that's a bit of an idea why. It should also be pointed out, though, that soft law is actually really important in developing many of the things that we then have go on to become treaty text. So just because we say it's soft law now doesn't mean it can't be part of a binding international treaty in the future. So I hope that answered that question. If not, obviously put things in the chat. I can't see the chat till the end, but that's fine. And if something comes up that's super important to him, and just jump in at any point. And then let's see the second question, which I think is a really important one. Do or can various MEAs borrow principles or other terms from each other? Absolutely. Yes. Yes, definitely. And this is actually where we've seen things like the principles that we saw from the Rio Declaration or even Stockholm come into the treaties themselves as both hard law principles and also elements in the preamble. And then those elements that were in, say, the UNFCCC and the CBD and the Convention on Desertification, then from 1982, then have grown outwards to be in almost every other environmental treaty since that point. So absolutely, they do borrow principles from each other. They can borrow other terms as well. So we've seen a lot of, especially some of the more standard format terms, like for secretariats, like for conference of the parties, etc., be borrowed from one MEA into another. Again, sometimes it works, sometimes it doesn't. We don't want to cut and paste too much, but it can work quite well, and certainly there's nothing to bar that from happening. The third question that we had here is, playing with my screen, is what is the role of UNEP in international treaty regimes? So first of all, I would point out UNEP's role, to the extent that it has one in international treaty regimes, is those that fall within its jurisdiction. So those relating to environmental issues. You wouldn't, for example, see UNEP working on a treaty or administering a treaty that has to do with trade unless it's environmental trade, etc. So that's number one. Number two, UNEP has the ability, if it is authorized by the UN Environment Assembly, so UNEA, to convene negotiations for the creation of an international treaty, like we are seeing now with the plastics treaty. And it also, if it is challenged or tasked with under the terms of a treaty, hosting a secretariat, it has the ability to host a secretariat. It has the ability to provide oversight and administrative functions for various treaty regimes. It cannot, however, do anything without an authorization, an express authorization, first of all, from UN Environment Assembly to do things like host treaty negotiations, start treaty negotiations, have a secretariat for treaty negotiations, or even start the first steps towards a treaty by having, for example, open-ended working groups or consultations. All of those need approval from the UN Environment Assembly itself, typically in the form of a decision. And it also then is dependent on what the treaties themselves say in terms of saying that UNEP will host, for example, as the secretariat body, or it will be the host institution for whatever the treaty body might be. So once it has those powers, UNEP is a wonderful and truly vibrant, vital organization that does many different functions, but it has to be given those powers by the treaties themselves and also by the UN Environment Assembly, because it is an international organization, and it's not like you or me or anyone on this call or anyone on this watching this recording who is a natural person. It is a created entity. It's an organization. So as a matter of law, the rights, the obligations that it has comes from whatever instrument created it. So hopefully that helps. And then we have a few more quickly. Let's see, this is a duplication. Some of these are duplications. I apologize. There is a point to remind you all of here, and that is that states cannot be required to ratify anything in international law. So in the WhatsApp group, if we have people who are in the WhatsApp group, there was a question about this, and I just wanted to clarify that states as sovereign entities have the ability to choose whether or not to ratify an international law instrument. And we can have pressure put on them in terms of funding or other types of assistance, capacity building, et cetera. But we can't actually say they have to ratify something because that would violate international law. So just a reminder on that. And finally, how do the national circumstances and capabilities of a state come into its international treaty obligation or under a treaty or obligations, plural, if we're looking at MEAs? Typically, this will come into play when we're looking at the treaty text itself, anywhere that we see a reference to this. So if we see that an obligation exists, but subject to national circumstances and capabilities, or common but differentiated responsibilities, et cetera, then that means that particular element is subject to this limitation. And also in reporting, typically we see this. So that's how we would use it. But we wouldn't use it necessarily to always argue about a state not complying or a state not being required to do things, because it is required to do things under a treaty regime, typically, unless there is a provision saying, depending upon national circumstances and capabilities, et cetera. So I think those were the big main questions. Obviously, I'm expecting that there will be more this time. And then if we don't get to those, we will get to those on the weekend, but just to get to the ones we had left. Now, I was trying to find a really good graph or like some type of visual for this, and I couldn't. So we have a little Venn diagram here, which may take many of us back to, high school or grammar school, which for some of you will not have been that long ago. For some of us, was very long time ago. Anyway, when we're talking about the nexuses between MEAs, I did this graphic to show you all, remind you all that things overlap, and things overlap in any field of study, not only science, not only math, but also in law. And this does happen periodically, especially when we're looking at a really niche area or something that tends to be niche, like environmental law. And many things touch upon the same type of concern. So if we're talking about pollution, we'll have multiple forms of pollution that all cause, say, damage to biodiversity. So we have to figure that out. Who's going to regulate what? How are we going to regulate it? And how do they work together? And this leads to the idea of regime convergence. Now, if you have studied global governance or related issues, you will be familiar with a very large literature on this and evolving literature on this. In a very simple way, just to put it in a really simple way, the idea of regime convergence is when treaties, whether they're international or regional or even bilateral, come together around a particular topic. And we try to figure out, because they're all converging on this point, how do they work together? What gets priority? What happens if there are overlaps generally? What happens if there's a conflict between, say, a provision of a World Trade Organization agreement and the CBD protocols relating to the trade in various types of biodiversity and free prior informed consent. The idea is not that regime convergence be thought of as a bad thing, but that it be used as a tool to make us figure out what are all of these connections and how do we work around them in the international system we have, which is very much focused on the treaty itself. So that is why we are talking about the nexuses now that we've talked about some of the MEAs. And how do we handle these types of things? What do? We write, if you're me, academic papers on them that I'm sure could be used to put many people into a nice little nap state if you need one and you're having trouble falling asleep. But in addition to the academic format, if we look at the MEA texts themselves, there are hints, and sometimes there are actual COP decisions that tell us how this should be handled. So if we are lucky, and increasingly we are lucky in the sense that increasingly treaties have this, we have a textual reference. So actually in the text of the treaty itself, which refers to other applicable treaty regimes and also soft law instruments that may be related to the treaty. Now, typically or often we see these in the preamble. Please pardon my subtle plug for Sweden with the mug. I know. So Sweden, if anybody here is from Sweden or in Sweden, there's my plug for that. I will try to rotate the mugs periodically. I think last week was Singapore, so we'll rotate. Anyway, equal love around the world. So when we think about the textual references with other treaties, we often think about the preamble, because if you read many preambles, you will see typically a very long paragraph that lists out all other related treaties and related treaty bodies, and often soft law instruments as well, that are going into or informing the creation of the particular treaty we're looking at. And the reason we do this is to make sure that we have a hook. So anything in the preamble, as we know, is not legally binding for the treaty text, but it can be used as a hook to allow for things like coordination with other treaties, for the Secretariat of, say, the proposed plastics treaty to work with other secretariats of other related treaty bodies, to form other types of governance systems, etc., if the actual treaty text doesn't talk about it, but COPs in the future decide they want to do this. It's also just a standard practice to explain historically how we've gotten here and what other types of principles are coming in from other treaties or should be understood as informing the creation of the treaty. So that's where we see typically the initial reference. We often see things like provisions or sub-provisions within an article that will, of a treaty, so again, in the treaty text, that will recognize the role of other treaty regimes and other secretariats and expressly authorize cooperation between either the Conference of the Parties themselves or the Secretariat, or a combination of both, so that multiple secretariats can talk to each other and work together. The conferences of the parties can talk to each other and work together. And sometimes we even see this in the idea of authorizing joint committees or creating joint committees. Typically, this will be coming out of a COP, especially now it will be coming out of a COP, where there is an authorization for, say, the Basel, Rotterdam, and Stockholm conventions to both their COP and also their secretariats to coordinate with the Minamata Convention on Mercury and its secretariat and its COP for issues that kind of are shared between the two. So pollution and related issues that are shared between the two, to come up with a set of understandings as to what they might want to do together, what policies they share together. But when those committees come up with any recommendations, it has to be remembered that if they're supposed to be adopted, if the recommendation is to adopt a set of guidelines on mercury pollution and the transfer of mercury across borders in a way that would implicate some of the BRS convention elements, what would need to happen is that both the applicable secretariat and the Minamata Convention and the Conference of the Parties of the Minamata Convention would need to adopt those measures for their purposes. And then the applicable COP, as well as the Secretariat, but really the COP for whichever it would be, Basel, Rotterdam, or Stockholm, or all of them, would need to also adopt this as a separate COP decision as well. So we can have sharing of information, we can have the development of joint proposals and guidelines, et cetera, but the COP systems are still separate because the treaties are still separate. Like we talked about last time with the question of why can't we just have one really massive COP, which the more I thought about would be really fun. But anyway, it wouldn't work for many reasons, including the fact that everyone does have their own COP for each treaty. So those decisions would still have to go back. And just to highlight, before we get into some other treaty regimes, just to highlight that it has been considered by legal scholars as well as by certainly many practitioners, and the last time I heard it discussed was about a year and a half ago during the Minamata Cup, that you cannot, this is a well-established principle, you cannot make the provisions of a treaty, so let's say the plastics treaty, you cannot say that part of the plastics treaty will govern or relate to whatever the Minamata Convention on Mercury decides in terms of handling mercury in plastic products. It is not under international law acceptable for the decisions of one treaty body, so the Conference of the Parties of the Minamata Secretariat, to become automatically binding on the state parties to another treaty, so to, say, the Basel Convention, unless that particular convention has met, its COP has met, and decided it wants to be bound by those provisions. So it's a very nuanced difference, and I know it might be a bit much for a lot of you who don't have a lot of background, but I wanted to bring this up because, again, it will potentially come up in our discussions of the plastics treaty and proposals there. So I wanted to kind of mention it and introduce it early to you, in the sense that no matter what level of coordination we're looking at, each treaty is governed by its own COP as well as the treaty itself, and it has to have decisions that are made by that COP to be legally bound. For those of you who are so interested. For those of you who are not and want to get on with some other information, we have nexuses between other types of treaty regimes, and they run a full gamut because environment cuts across everything. When we think about environment and environmental protections, we really have come to understand that this is a multiple pronged issue, and it connects to many different things. And certainly we know it connects to human rights bodies and the idea of human rights itself. And so many of you will know that a number of different elements in international law have come to recognize legally the connections between environmental concerns, environmental health, and also human rights issues. And some of you may remember, I know it was at the tail end of the official pandemic, so it did get a wee bit lost in the shuffle, but at the international level, you may remember that in 2022, the UN General Assembly actually formally recognized, as a matter of customary international law, that there is a human right to a clean, healthy, and sustainable environment. This is something that the year before, the UN Human Rights Committee also heard and also agreed upon. So it's something that has a great deal of traction in international law now as custom, and, for example, is an element that has been used in the currently pending advisory opinion request from a number of different states to the International Court of Justice relating to state responsibility for climate change and associated impacts. So very important, very timely. We also have it should be pointed out, a number of MEAs that recognize the direct connection between whatever they're trying to address. So climate change, protecting biodiversity, ending pollution or controlling pollution, etc., and human rights concerns, human rights issues. Sometimes we see this directly in the treaties themselves. Sometimes we see this in various decisions of the conferences of the parties, but we do see an increasing understanding from MEAs that they have a connection to human rights outside of their own treaty system. And we also have come to see in several different treaty texts that there are direct related references to environment and environmental concerns in the textual elements of the treaties themselves. I could again give an entire lecture series on human rights law. I would happily do it. I would love to do it. It's another area of my passion. But just in a very, very brief nutshell, there are a handful of what we kind of call the core international human rights treaties. So these are the main ones that come kind of directly at the UN system, high-level international treaties coming from the Universal Declaration of Human Rights in the 1940s, which was not a binding treaty. Again, it was a declaration, but coming from it. So we see things like the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the ICSCR, which you see on your screen, we'll get to in a second, and then a whole line of treaties coming out of those. Things like the Convention on the Rights of the Child, the Convention to eliminate all forms of racial discrimination against women, so CEDAW. The Convention to Eliminate Racial Discrimination, what we call CERD. A number of other different conventions that come up, specialized ones in particular that look at things like torture and forced disappearance, also things like protection for migrant workers, etc. So we have a number of them. And they are all very important. And again, maybe we do another training on this in the future. If Shellen were here, she would sit here wanting to yell at me for coming up with more ideas, but she's not. So there we go. But the ones that we have specific treaty references for, so they include in their treaty texts references to environment, include the Convention on the Rights of the Child, which chronologically is not first, but I put first because it is universally one of, if not the most ratified conventions in the world. It lacks about 3 states at this point as signatories, but it is universally held in high regard. And there are 2 references to the connection between human rights and environment for children in the treaty. The first comes in Article 24, which talks about a healthy environment in connection with the right to health that all children are recognized as having under the convention. And the second comes actually in Article 29, which relates to education and includes state obligations to ensure that their education systems include teaching respect for the natural environment as part of their overall learning practices. So really interesting, really novel ways of getting it in, but those nexuses are certainly still there. The International Covenant on Economic, Social, and Cultural Rights talks about environment in Article 12, again, in connection with the right to health, so the right of everyone, adults and children, to the right to health as a fundamental human right. And then we see, oh, wow, that's font is small, I apologize. And then we see that not only have these treaties actually included textual references, but the treaty bodies, so the committees that are charged with oversight. We don't have COPs to the same extent. We don't have the systems typically like we have for the environmental treaties. We don't have in human rights law. In human rights law, instead, we do have periodic meetings of the parties together They're not as necessarily ceremonial and big and overwhelming as the COPs can be for environmental purposes. And we also have a very important set of compliance mechanisms that exist in almost all of the core human rights treaties, where there are committees within the system that for each particular treaty itself. And one of the powers of those committees, which act as much more than a secretariat, they act as an enforcement body, is to hear complaints, typically from individuals or groups. So, for example, civil society actors, etc., regarding state practice and often malpractice or failure to follow their obligations under human rights treaties. And in addition to this, the committees have the ability to issue what we call general recommendations. And general recommendations can be viewed as soft law instruments in the sense that they are considered to be persuasive. They are not requirements, but they are considered to be persuasive. And they are written to address new issues that come up or new questions that come up about the terms of the treaty and their application in the modern and evolving world that we live in, and how various issues should be handled and how they actually are handled by a number of different states under their particular treaty regimes. So we have a number of general recommendations or comments. The Committee on the Elimination of Racial Discrimination uses recommendations. Others use comments. Either terminology works. So we have, for example, the Committee on the Elimination of Racial Discrimination, which does not, in the treaty itself, have a reference to environment. In a 2024, so very recent general recommendation on equality and freedom from racial discrimination in the enjoyment of the right to health, include environmental issues, especially pollution, in the health discussion, and look at things like the location of various sites of pollution in relation to racial discrimination aspects and charges under the human rights aspects of the treaty. We have the Committee on Economic, Social, and Cultural Rights, which links to the ICSCR, so textual reference is already there, but making several different comments, general comments, including from 2022 and comment number 16 or 26 rather, where it talks about the connections between land and economic, social, and cultural rights, and looks at land not only as actually having access to land, but also issues like pollution and environmental degradation in land itself. And also from 2000, General Comment 14, which addresses the right to the highest attainable standard of health, which looks at Article 12, and we know that that obviously contains environmental references as well. Now, we also have several others. So the Committee on the Elimination of Discrimination Against Women, CEDAW, has issued a general comment looking at gender-related dimensions of disaster risk reduction in a changing climate, and that has a number of different connections to environmental concerns, as does the Committee on the Rights of the Child when it wrote in General Comment 26, which is quite recent. And I actually had the really interesting ability to participate in some kind of background gathering of information meetings on, which looked at specifically children's right and the environment, especially in terms of climate change. So it's a really emerging topic, and it's one that keeps changing over time. And
Hello,
I should
Alex.
mention that this lovely image you keep seeing here is actually of the Human Rights Committee chambers. So if you're ever on a tour and you're in Geneva and you get a chance to go to Palais des Nations and take a tour, you will see this. And it is a truly lovely room. And I have just stumped the translation thing that I see here because it could not translate Palais des Nations. So anyway, there's that. What other treaty regimes exist that we should talk about? I think one that will keep coming up in the context, certainly of the plastics treaty discussions, is the World Trade Organization. And the questions of how we use things like environmental concerns to regulate aspects of trade, and how we make sure that this works in conjunction with the general obligations which the vast majority of states in the world have undertaken in their role as being members of the WTO. And the WTO is a very complex entity in some ways. It's also rather simple in others, in a sense of just understanding what it is and how it works. And that for most of you is more than sufficient to then understand how the treaties work together. So just as a background, because I think we have enough time to do this. I have like multiple watches just to make sure I don't go way over, because as Shellen knows, I could talk forever, and I think Jimenez realized this too. Anyway,
I'm here. Alex,
Shellen, are you here?
I'm here.
You're here. I'm so glad. Anyway, welcome. So you know how much I love talking about WTO and trade and plastics, but anyway, just as a background. The World Trade Organization is relatively new in that it was created in the 1990s. It builds on a very old trade system that we call lovingly and colloquially the GATT, the GATT, which was an informal, so treaty-based, but without an actual structural body to enforce. International law agreement that went on for decades. It's the General Agreement on Tariffs and Trade. It established the concepts that some of you might know, like most favored nation status, etc. And after the end of the Cold War, which again, I remember as a child, but none of you most likely will, which is fine, which is good. I have more gray hair. It's all good. Anyway, but after the end of the Cold War, there was a feeling that the economic and political situation had shifted to the point where an actual structural element, an actual organization could be created to enforce the GATT and to further free trade as a way of trying to both continue on trading practices that already existed and then help states that were coming out of the Soviet bloc, as well as those that were still handling a number of different issues from colonization and decolonization, to advance forward through trade. So the agreement for the WTO took elements of the GATT, modernized some of them, and turned that into the core agreement for the creation of the WTO and the WTO structure and free trade system. But it also is accompanied by several other treaties that address very specific aspects of trade. So things like sanitary and phytosanitary measures. So for health and for biodiversity protections in trade. Things like government procurement, things like trade in services, intellectual property, all of these things, and a number of other ones, agriculture, etc., are all now separate treaties under the World Trade Organization. And when a country wants to join the WTO, it's actually one of the most heavy burdens you can take on of all international organizations, because it is assumed that it will take at least 10 years. And so there are actually provisions in the admissions process which say, expect in a rudimentary way, right? Expect it to take 10 years. If it takes more than 10 years, we will evaluate why. But expect that when you put in your application, say today or tomorrow, April 4th, 2024, if you're a state and you want to become a member of the WTO, that is fantastic, but you might not become a member until 2034. Why is that? Because you have to make sure that prior to joining, all of your legal and regulatory practices, as well as practices on the ground, are deemed to be in compliance with the core treaties that are part of the WTO system. And this takes a very long time. It can take a great deal of effort and money at the national level to, for example, revamp all of your customs practices. Even something really simple like revamping all of your forms can take a great deal of time. And then every other country that's a member of the WTO has the right to say, we want to see your books. We want to see your economic information. We want to see your legal and regulatory practices, and you have to open them all up, and everybody gets to take a little nose around and snoop, see what's there, and then when they're ultimately satisfied, there will be a vote, and presumably at that point, the country will be admitted. So it takes 10 years for this particular reason. Well, once you are admitted, you are bound by those particular treaties. You have to ratify them, of course, but you're bound by the treaties. And so there is sometimes a concern about whether or not things like regulating trade in endangered species under CITES, or various aspects of the pollution system under BRS, so hazardous waste, and also issues of free prior informed consent or prior informed consent, and the trade in certain aspects of biodiverse species under CBD, these are all examples, whether this would cause a conflict if you were to be a member of both treaty regimes, the WTO and any of these other treaty regimes in the MEA context. And the way that they're written, the answer is no. The way that they're written, they don't cause any type of conflict. We've never had a decision. There is a separate dispute settlement body within the WTO. We've never had a decision that any of these types of trade provisions violate WTO law from the dispute settlement body. And indeed, we have often co-committees and working relationships between WTO and these other trading systems. Now, we will come back to the issue of trade in the plastics context because it is an important one, and it is one that is very much controversial right now. But I wanted you to understand that there is this connection potentially, but that the way the other treaties that address it have been written, and to get back to one of your earlier questions, many have actually suggested copying a great deal of text out of those provisions for plastics, would work in many other contexts as well, and has worked thus far. So that is the WTO. The World Maritime Organization, which is also on your screen, as the name suggests, regulates international maritime practice. I'm sorry, it's the International Maritime Organization. The World Maritime Organization is a more academic entity, and it looks at assisting the IMO. So the International Maritime Organization is the entity that creates these types of regulations. They create treaties, but also regulatory suggestions and suggested practices. And I mention them here because there are a number of treaties that have a nexus with pollution. So there are a number of treaties on the practice of, say, tankers. So in tankers that are carrying oil, petroleum or unrefined oil, on the open seas, as well as within various national jurisdictions and national territories, and what happens if there is an oil spill, what happens if there's a leak, what type of ship is supposed to actually be used in transporting this type of product, because it is in fact considered to be dangerous or potentially dangerous to the environment. So there are a number of nexus areas on various types of pollution. We're also starting to see a lot of IMO interest in other types. So not just oil, not just things that come off the ship, not just things that attach to the ship and then kind of come into port and come along with the ship. But we're also starting to see a lot more interest in things like plastic pollution coming off of ships, and other types of pollution that generally comes from what is carried on those ships. So that's a really important nexus with environmental concerns and with the MEAs themselves. Again, there has not been a suggestion that this would be a conflict. In fact, many look at this as reinforcing and quite beneficial. Hopefully. It's always nice to hear that it could be beneficial. And then we have a number of different regional treaties as well. And I mention these to you because depending on where you are in the world, they could also be really important to understand in terms of what they do in the environmental context and how they can also intersect with some of the other environmental laws that we have, the international environmental laws that we have. So the first one, and the one that I think many of us think of first when we're looking at regional treaty regimes, is the European Union and the various forms of law that have been adopted by the European Union. But I always, no matter who I'm teaching, no matter where I'm teaching, I always stop at this point just to remind everyone that the EU is a different type of organization than the other regional organizations we have. So the other regional organizations that we have, for example, the African Union, the Organization of American States, and ASEAN, which is the Association of Southeast Asian Nations, and there are many more, but these are many of the main ones here. These are all voluntary organizations like any other international organization that states and countries choose to join. And when they join, they are all equal members. It's on the horizontal plane. Each state negotiates with each other in hopefully good faith and hopefully on equal footing. But the decisions that are made by, for example, the African Union, then they're taken by the African Union as, for example, the UN General Assembly takes decisions. But then in order for them to be ratified and to be binding on the particular member states, they have to be adopted at home. So this is very much the same practice we've already seen and talked about internationally, but just in a smaller context, so in the regional context. And I say a smaller context, but when we think about these regions, for example, the African Union is 54 member states. So it's smaller, but it's still not small. The EU practice is different. So when the EU was created, it created a supranational organization, not technically a regional organization. And again, very simply, the difference is that when a state joins the EU, it agrees to give up a portion of its sovereignty to the EU in a different way. And it agrees that when the EU Parliament, first of all, it agrees to an EU Parliament, it elects members to the EU Parliament. So it's not just one person per country sitting in a room. It elects members. Those members sit by party. So it's a different way that we profile things than in, say, for the UN context where everybody sits behind their national flag. And then the decisions that are taken by the European Parliament become automatically binding once they are adopted on all member states, unless they fall into a very small exemption category where the member states have to agree. So typically things like national security, certain aspects of health, etc. So very limited ways to get out of it. Otherwise, you're bound by what the European Parliament says. So it is a very different system. And thus we see a really interesting phenomenon where part of the sovereignty given up is actually to negotiate treaties. So when, for example, we are at the plastics treaty negotiations, we will see France, we will see the Netherlands, we will see Belgium, we will see any and all of the EU member states. They have the option to be there, and they will frequently speak, and they will frequently be very active. However, there is also a European Union representative or body of representatives and presence. And when we get to things like voting, the European Union is authorized exceptionally with one or two other very small niche topics that we can't get into today, but niche areas in typically the Pacific, South Pacific. The EU is authorized to, as an entity, as a bloc, vote for the entire amount of its membership who are there and present. So it means it can represent all of its membership, and it does in negotiations rather than each country representing itself, which happens in the regional organization context. So I just wanted to give you all a sense of that and to explain that the EU has adopted a number of different laws that relate to many aspects of environmental concerns that are intended to work in conjunction with the existing treaties that we have as MEAs. The regional organizations have adopted, depending on the regional organization, either their own declarations or their own treaty regimes that work in tandem, typically, with the existing MEAs that are there. And they also, in their own meetings, their own sessions and COP equivalents, have adopted a number of different types of decisions that support ongoing activities in these areas and that are intended to support national treaty regimes when they when countries sign on to them. We also have a number of different regional agreements for fisheries and also for the regional seas themselves. And I again reference them because these tend to come into certain aspects of convergence with pollution, especially with maritime pollution. The regional seas conventions actually also typically contain provisions relating to pollution on land that then gets into marine resources. So there are a number of different areas of convergence. Thus far, we really see that these regional entities try to work to properly converge and really facilitate a dialogue and cooperation with existing multilateral environmental agreements. But there are things that we certainly have to think about when we are thinking about how do we enforce existing multilateral environmental agreements, and then also how do we make new ones like the Plastics Treaty, which work together with the existing obligations that member states have, so that when we're trying to create a new treaty or implement an existing treaty, we don't do it in a way that then causes a state to go along with whatever treaty we're looking at, but then violate obligations under another one. That would be very bad for the state. It would also be typically very bad for the environmental interests that we have and cause a lot of problems. So that's why we talk about regime convergence so much. And that's why I wanted to kind of end our discussion of MEAs on that. And just with a reminder that, again, we talked about a number of things. We talked about history. We talked about soft law. We talked about how it created hard law, or MEAs, and what MEAs, multilateral environmental agreements, are. That was all on Tuesday. And then obviously just now we talked about the various nexuses. So this is what we got for the week, or at least hopefully this is what you got for the week. I see that I'm exactly at the hour, so there's that. My timing for once actually worked. So with that, I will stop sharing the screen. I will just do a little teaser preview that next week we will start talking about the treaty negotiation process itself. So we will talk about what goes into a treaty negotiation. Many things, many more things than we might think. And try to give you a bit more familiarity with that. And then obviously in week 4, we'll be using the Plastics Treaty as a case study to really see how all of these things go into effect. So I will stop sharing my screen. I can figure out how to hit the red button. So that's amazing. There we go. Stop sharing the screen. I see we have a number of comments in the chat. So I will turn myself over to, I don't know if it's Jimena or Shellen or who it is.
It's me.
Is it you with questions? Are you hiding? I don't see you. Where are you? There
Let's
you are.
see. There we are. Yes.
Hello.
Hello. Good to see you.
Good to see you too. I
Did
missed
not
that background.
Oh yes, so I'm exposing my normal Zoom background right now.
Mhm.
But yes, apologies for being late, but shout out to my amazing team that works
Yes.
on plastics with me. Jimena, Samuel, Kartik, I think is here. I tried to look at the list. But anyway, questions. And this is actually a really great question to start off with because I know, yes, a little sleep deprived, Shellen, but yes, we keep going because of our passion in the world. So is
Yes, we
the
do.
decision at the end of international conferences like UNOC considered a treaty? And for those who don't know what UNOC is, it's the United Nations Ocean Conference that happens every few years and will be happening in Nice in the coming months.
Yes, in June, in the beginning of
In
June.
June, right after literally OEG
Let's see. It's
3.2,
early.
and then
Yeah, June is UNOC, and then Science Policy Panel, and then General Framework on Chemicals. So yes, it's a very busy month with lots of acronyms. I'm still waiting to see if I have to go to UNOC. It would be very nice if I do. Nice, June, stunning. Anyway, but to answer the question, decisions at the end of UNOC are theoretically binding on the organization. They are binding on the states that agree to them. What the problem with UNOC is that it is a conference, it's an oceans conference. It is not a COP per se. So the COP decisions are strictly binding. So once a COP decision comes out, for example, from UNFCCC, from CBD or BRS or any of our other acronyms that we have for treaties, those become binding on the states themselves unless there's a vote and the state particularly does not vote for it. But in other contexts where we have a meeting that is more soft law oriented, like UNOC, then those decisions are persuasive authority. So they are not legally binding. It's a great question. Thank you.
Is a great question. It is caught the conference has been there's a lot of hype around it this year
So much hype.
as well. Yes. Yes. Okay, next question. And also don't forget, if you have a question or you want to ask it, to say it in the chat. Jimena is taking notes and making a list because that's just the most diplomatic thing to do. So is compliance or alignment of state climate actions to the common but differentiated responsible EDRRC principle legally important, considering its status not even recognized as a principle with hard obligation?
I think everything is legally important to take note of, at least in terms of it being a proposal, so we know what it is and how we move it forward. At this point, the common but differentiated responsibility element is, so there is legal authority for that as part of the Rio Principles, and then as part of many of the treaty regimes and many of the laws of various countries. The extended idea of CBDR is not yet legally binding. It is something that is a suggestion and is argued as persuasive authority, but legally not yet binding.
Awesome, awesome. And then who understands the practice, who undertakes the practice of doing regime convergence?
Oh, this is an excellent question. So it's a multi-pronged thing. Part of it is like people like me, right? Really boring people like me who like to sit here and write books and write articles and give talks about it. So, we do this at like a theoretical level. The actual day-to-day work of regime convergence is done typically by the secretariats of the different treaties involved, who are interested in this, and once they get authorization from the secretariat and or the COP, depending on how the language is used, what the secretariat kind of has internally and what it has to get permission for, then they will do it. And so they will sit together, they will have meetings, they will have conferences and try to figure out these issues themselves. And then once they do that, they will make proposals, which typically then have to go to the next COP cycle for approval. So it's multiple layers all working together to try to actually make it work. Theoretically.
Amazing. Yeah. Let's get to, it's, I think I missed a little bit of that part, but yes, it's such a complicated world.
It is.
Next question. How do we ensure that member states adhere to these agreements with the rights holders in mind? That's a great question. And I think we're experiencing that question in the plastics treaty at the moment as well.
So important and so difficult to answer. So the way that we do it is really to look and see kind of what space is already there and how do we use that space appropriately. So things like provisions in a treaty that talk about international cooperation and coordination often are a way in, because that includes not only states but also NGOs and civil society members, etc. Also through the major groups. So CYMG, again, huge plug, but as well as the other major groups, all have a status to be able to start participating or continue participating in a number of different treaty entities. Unfortunately, the way that the COP systems work and the negotiation systems work, it is very much state-centered and state-centric. So we will never, unless international law changes greatly, we will never have a situation where everyone is on equal footing. But trying to make sure that that type of language is used, trying to make sure that cooperation and coordination is maximized, and working with major groups, etc., is typically the way that we do it. Also events, so official side events at conferences of the parties or negotiations, publications, demonstrations. There are a number of demonstrations that go on typically at any type of COP. Peaceful and within the law, please. But this is another way of at least manifesting, various points of view. These type of events, webinars, etc. All of these are ways to kind of keep the presence there, even though there is a different status, keeping the presence there, keeping people's voices very active. We've seen a number of different strategies in the plastics treaty. We've seen some that are much more aggressive. We've seen some that are much more kind of collegial and trying to provide information and support. I don't know, Shellen, if you want to add anything, because you obviously have your own perspective on this.
I think you said it well. I think you said it very well. I agree with mostly what you said. I mean, I think a great prime example of more aggressive was we saw at Inc. 5.1 with the indigenous nations and communities who were protesting and being loud.
Because they were not allowed to speak and they were not given the floor when requested. And certainly from their point of view is that they have rights, they are rights holders, and they should be heard. And they had elders as well who were there, who were ready to really add a lot of information. And it was a very contentious moment and a very tense moment.
Yes. Okay, next question. Regarding the role of the preamble in the eyes of international law, which is another great topic.
Yes, indeed it is.
What is the role of the preamble, if any, in interpreting the meaning of and implementation of the treaties? One thing I will say, an experience real quick with the preamble was the Pacific Islands, who have been really pushing to make sure they have that, specifically that the Pacific Islands are affected by plastic in the preamble.
So the preamble, it is not legally binding, but it does matter because it is an interpretive tool. And it's an interpretive tool that we are able to use in subsequent COPs, in making decisions on annexes. Also, if there are legal questions. So if there are legal questions that come up that go to the International Court of Justice, if there's a dispute between two member states and it can't be solved, or between the treaty by the COP and a particular country. If it goes to the ICJ, the preamble can be used. But what we see preambles used for a great deal is COPs then saying, okay, this is in the preamble. It's an important consideration. And so we're going to create committees, or we're going to include it in our evaluation standards, or create new guidelines, because COPs are able to use anything that's in the treaty typically, unless their parameters are written differently, but typically they are. So I think one of the best examples is the idea of just transition. So just transition as a term is in the Paris Agreement, but it's in the Paris Agreement in the preamble. However, coming out of that, from 2018 onwards, there's been a sustained push by the COPs to actually create an oversight body, like a just transition mechanism, as they call it, and then empower that with more authority to oversee things like the global stocktake and what aspects of just transition are there, to promote discussions on just transition and figuring out how to put this into national legal practice. So just by having something in the preamble, there is what we call a hook. I know it's not very technical, but it's a hook. And it's a way to make sure that the future COP has the power to talk about these types of issues. And I know there are some issues that are very, very highly controversial. For example, in the plastics treaty, where the feeling is if you can just get it into the preamble at the very least, at a very minimum, then we'll be able to talk about it in the future. So that's typically why we have so much vested in the preamble. In addition to it just being like the nicest sounding part of the treaty, the most elegant, really, the most beautifully written. Yes.
It is actually. You're right about that. Then you get into the nitty and gritty stuff.
I know, but it sounds so lovely, recognizing whatever, it's a beautiful thing.
Okay, next question, and then we'll have an open mic. Laura, I believe, I apologize, I said your name wrong, will be after this question. So in what ways are the supranational organizations different from the ones who are regional organizations?
So a supranational organization is one where the organization is a legislative body, and whatever it decides will then become, with some very limited exceptions, automatically binding on all of the member states. So the EU is our example of this, right? So the EU Parliament makes a decision, passes a law, it becomes automatically binding on all EU member states, unless, for example, it relates to national security or a health issue or a morality issue. A regional organization is very much like the UN or any of the other organizations at the international level. Everyone comes in, they don't give up much of their sovereignty at all. And if the Organization of American States makes a decision, the Organization of American State members are encouraged to be bound by it and theoretically are bound by it. But it is not having the force of law in the same way that it comes from a higher political power. If that helps at all. And I see, I was just looking in the comments here and I see Gizem being very shy. Please don't worry about it. It's fine.
Honestly, maybe just a quick story before we get to the open mic. When I attended my first negotiations, I was so terrified. I actually almost bought a plane ticket home and did not go to the first day. And it was because of another member of our group, Babette, who is this amazing young scientist from Australia. Yeah, and I was literally forced to the negotiations because of the study with her. So even, trust me, we may seem confident up here sometimes, but we weren't always confident. So please ask your question.
Oh, no.
Okay.
Oh, no. I mean, when I first started doing academic speeches, I would look around the room and go, all right, If I get under the table and crawl quickly, will anyone see me go to the door? Like, can I get out? Is there an escape route? It's a common thing. It is. Still sometimes feel that way. Anyway. I just as a correlate, because I see Rita's question as a perfect correlate. So generally the decisions that are passed by the AU are they're highly persuasive. They are not considered to be legally binding the way that, say, a decision from the European Parliament is legally binding. So they are different because the AU is a regional organization. It is not a supranational organization. Thank you.
Now we have a lovely open mic question.
Excellent.
Oh, she might have to, oh, there we go. Unmute.
Hello, Miss Alexandra. How are you?
Very well,
So
Nora.
thank
How are you?
fine, thank you. So thank you so much for your comprehensive explanation. Your insights provided a clear understanding of the connections between different treaty regimes and their implications. So I really appreciate the depth of the analysis you shared with us. So if I will thank you from today until
Thank you.
tomorrow, it is not enough. So
Thank
my
you so much. I'm so
question So my question is, what role do power dynamics play in shaping international treaty regimes? And how can smaller nations ensure their interests are protected? And my second questions,
Mhm.
how can the WTO's trade rules be reformed to better integrate sustainability and environmental concerns? Thank you so much.
Thank you, Nora. Thank you so very much. And these are really, they're great questions. Let's see. Shall we do I might actually do this strangely and do the first question first. Usually I go for the last question, but it is a really important question. And power dynamics are unfortunately the reality of life. And so we say that states are all equal. And legally they all have one vote, etc. But obviously the power dynamics are very different. And you see that when you go into a negotiation, both in terms of just political clout, etc., but also by numbers, right? So I think I mentioned this in one of the earlier lectures, but we have delegations that come and you basically can think of them as like a negotiating flight crew in a sense of when someone is up and negotiating and working, somebody else is sleeping so they can take their place and they just rotate through and they have lots of rest and food and they're really close to the venue and everything else. And then you get other delegations that have one or two people there for the entire time from smaller countries. And it is really difficult. So what I have seen work a great deal, I've seen two things work. First of all, it is small states giving interventions that are quite powerful. So not only being present in the room, but also speaking and speaking very powerfully, very pointedly. For example, from the Plastics Treaty, Panama in INC 5 became hugely visible very quickly because they had a very, very powerful, very passionate speaker as one of their negotiators. So he just comes off the bat very, very able to connect with people. That's one strategy. The other strategy is also to work with other countries. So other small countries, either within the region or sometimes not within the region, but other countries that have similar issues, similar concerns. So that even if it's a kind of a shifting series of alliances, so you work with one country on one issue on trade, then you work with another country on a human rights issue, making those types of alliances. Now, it's very difficult if you're a small state because you have to figure out who those people will be and then talk to them. But once that happens, it can be a really powerful thing. Because if you start building a group of states that have a shared common interest, you start building that group and they become much more than one vote. They become a number of votes. They become a number of voices. And then they have to be dealt with in a different way. So it's a long process, and I wish I had an easy answer, because I really wish I could get all the small states to just have equal power and voice. But it is a strategy, and it does work. And thank you, Shellen, for adding Juan Carlos's name. He is truly brilliant as a speaker and really does bring in a lot of power. In a way that it's hard to do, but if you have someone who can do it, it can definitely help your cause. So Nora, thank you. And if you have more questions,
You're welcome.
let me know, or just message me and we can chat more.
Thank you so much.
My pleasure. We have Anania.
I'd
Is
love to see
Anania
the
there?
hand raise. Oh, yeah, let's do a few. Oh, I know there's a few questions, but I'm kind of enjoying this open mic vibe. Let's keep that going. Oh, we might have to undo her mic though. Let me see if I can find her. I think how the settings are. Can you raise your
This
hand
is all the
again?
technical stuff I leave to you, because no one wants me doing it. Trust me.
Hello, greetings from Tanzania.
Hello, how are you?
Thank you very much. Thank you very much for this very wonderful and interesting sessions concerning the issues of international environmental law. My question align with the issue of international environmental law and climate change. And the question is, why do we have international environmental law, which is common to all, despite of the fact that each country have their own environmental laws? But why we don't have a general climate change law or international climate change laws? And with that facts, each country have the decision whether they have the climate change act or climate change law, and other countries they don't have. For instance, in Tanzania we don't have a climate change act, but our neighbors country Kenya, they have a climate change act, though they have some challenges, but they have the law concerning with climate change act. Why we have the general international environmental law and we don't have the general climate change law? Thank you.
It's an excellent question. Thank you. And it's also, it's a frustrating question with a really frustrating answer, which is that because of the way state sovereignty works, each country will have a national commitment, a global commitment, say under the Paris Agreement. But the way that it implements that commitment, as long as it is implementing it, is left up to the country. Because at the end of the day, the countries are considered to be the most powerful and have the most political and legal force. So the reason that we see different countries having either no climate change law or climate change laws that are very strong or climate change laws that are very weak is that once the obligations, say, from the Paris Agreement go back to a country and it signs on and it ratifies them in its own way and according to the legal systems that they have in place in the country and also in the time. So unfortunately, the structure of international law itself is actually why we see this, because international law is a very powerful thing. It's a very useful tool, but at the end of the day, the most power is still with the countries to make those decisions. So they get to make that choice, and we can often see it change over time. We can see new things being adopted, we can see things being rolled back, etc., because of the will of the individual state. So not the most thrilling answer I could possibly give, but there we go.
Great. So I know we have Anya, and then we have a few more questions in the chat. So
We do.
Anya,
Well, that was Anania already.
no, that was Jean Paul.
Oh,
It's okay.
my screen said something different. And
Technology, you gotta love it.
I love technology. It's a great thing.
You may
All right.
ask your question now, Anya. make sure to unmute yourself.
I have already asked the question and
Yeah.
I really appreciate the response. Thank you.
Okay.
I think it's John Paul.
I think Jean-Paul, you
Oh.
are next. Yes.
My brain, I'm so sorry.
Yeah, John Paul. Hello.
The
Here.
host, hello.
Hi, Jean-Paul.
Good evening, everyone.
Good evening.
I'm Jean-Paul from Congo, DRC. I'm based in Goma.
Mhm.
Yeah, guys, I'm happy to meet you today. I'm a climate negotiator in my country.
Excellent.
Yes, and I have only a small question. It's about when we done this training, we will have the certificate or what?
For the
We will have a
yes,
certificate.
Shellen. Yeah.
Yes, there will be certificates,
Thank you.
of course.
Yeah.
Okay. Now going back to a question from the document. As most recent context, Kathmandu city, Nepal has been the most air polluted city in the world. We are getting skin allergies, nose tingling, and even eyes are burning. Now, what are the activities and programs you suggest to intake the control of air pollution? So I think they're talking about maybe what treaties or law.
For air pollution. And it is a horrible and multi-layered question. It truly is. So I would say first and foremost, the the Vienna Convention and then the Montreal Protocol for some aspects of it. But what we have to do is really look at what is the source of the pollution. Is it all from emissions? Is it from what type of emissions? Is it a transboundary issue? Is it something that's being generated in the country, or, as I believe it is, a great deal of it coming transboundary from other countries? So we need to figure out what countries those are, and potentially think of legal options with them. Again, what we've talked about in some of the earlier treaty discussions is the idea of, and principles on Tuesday, was the idea of avoiding transboundary harm. So those type of questions come up. Then we think about, once we know what it is it a carbon issue alone? Do we go for a UNFCCC and compliance questions? Do we go for other types of, if it's incineration of waste, do we go for various forms of the BRS elements and see what is being burned, for example, and is it something that is prohibited? So what we have to do is really break down, to the extent that is possible, what the source of the pollution is, and that gets us to understand what the ultimate obligations are. Now, there are also human rights elements to this, obviously. There are health impacts, we know, and you just cited a whole number of really terrible ones. There are impacts on things like rights to life, etc., in the human rights context. And that's a different discussion, and something I think, Shellen, you might not have heard me say we should probably think about doing in the future is also a human rights discussion. Because that's a different type of enforcement system, but it is there. And so as we think about that, that's another layer as well. But we need to really figure out what the sources are first.
Well, that's actually, I think, something that just exciting news that happened, what you're speaking about, is that the UN Human Rights Council just literally within the last hour or so just passed a biennial resolution on the right to clean, healthy, and sustainable environment.
Yes.
So,
and they passed it several years ago, and now we have it in the General Assembly. So it's a constant theme. It is. Yeah.
and with that, unfortunately, I don't think we have time for any more questions.
No, but we will take them all for Saturday.
Saturday, yes.
And if someone is not going to be here on Saturday, or able to access the recording, send me the question, please. I'm happy to talk about it, I guess. I mean, I'm
Great,
happy to stay on and
great.
talk too, but I know everyone else needs to go and do other things with their lives, so.
Oh yes, we all know you could talk for hours.
I can. It's a problem. Anyway.
It's a good problem. It's a good problem. Well,
I'm
thank
happy
you
to
guys
talk.
all so much. I will stop the recording, and whether you're
All right.
seeing it here or if you're seeing it recorded,